matter before the court is Waldo 24-181, State of Maine versus Matthew Pendleton. If counsel who are present would identify themselves by saying their names for the record together with the party they represent, starting with Attorney MacLean.
Good afternoon, Your Honor. Yes, my name is Chris MacLean, and I represent Defendant Matthew Pendleton.
Your Honor, Katie Sibley for the state.
Thank you. And we are being streamed, yes, by both video and audio. And Attorney MacLean, if you're ready to proceed, we'd be happy to hear your argument.
Thank you very much, Chief Justice Stanfill and members of the court. Matt Pendleton was found not guilty by a Waldo County jury in February of this year of murder, but he was found guilty of manslaughter. For the reasons we set forth in our brief, the manslaughter conviction should be vacated and the matter should be remanded for a new trial. Separately, we have challenged the sentence, and in any event, the court should remand this for a new sentencing.
I understand that since the green light is on with regard to the sentencing, you had an affidavit from a juror. That affidavit suggests what the jury as a whole believed. How is that not at least in violation of the principle, if not the language of the rule, and both contained in the rules of procedure, but as well in evidence, as well in case law, that we do not inquire into jury deliberations?
Well, this is how I view that, Your Honor. I view it like this. The United States Congress has passed legislation at 18 U.S.C. 3661.
Legislation not binding on us?
Fair enough, but I'm giving you my thought process to respond to you. That says that there shall be no limitation whatsoever placed on information to be considered by a court at the sentencing of a criminal defendant. The U.S. Supreme Court, which is binding on us, endorsed that in Peppers v. United States.
But hasn't the endorsement been with the qualification of reliable information?
Sure, it has.
And so if I start trying to speak for a whole group of which I am only but one member, doesn't that right away at least raise some question about reliability?
So the other thing I'll say, and I'll answer that, is that Rule 606 doesn't prohibit the use of juror information in the way that we used it.
Do the rules of evidence even apply at sentencing?
The rules of evidence don't apply at sentencing. It's up to the trial judge to exercise his or her discretion.
Which is why I talked about spirit rather than language.
Sure.
And in their discretion, if somebody walked in and said, I represent the Witta Pitlock Book Club, and we think that in this case you should be lenient, the judge would be well within his or her discretion to say, no, thank you, sorry, but no.
Right.
Isn't that the same thing here?
A court has to exercise its discretion. I mean, I've had...
Was it an abuse of discretion for the judge to not?
It was, because our client has a right to present whatever mitigating evidence he can at a sentencing proceeding. And in this case, there's no law that prohibits it. The U.S. Supreme Court seems to endorse the principle that...
Counsel, the U.S. Supreme Court endorses a principle. Do you have any authority at all to support the proposition that a trial court, a sentencing judge, should entertain comments from a sitting juror in that case?
I mean, the only way I can answer that is that there is absolutely no decision by this court. There's nothing in our rules of evidence. There's nothing in the federal rules of evidence. There's nothing in U.S. Supreme Court precedents that would prohibit it.
And you've not found any precedent that would include it? I'm assuming you've never found a case where somebody actually used it.
No, it's a case of first impression.
But if we were to bless that and the word got out, imagine people in the jury box saying, well, we think he's, really guilty here, but let's find him guilty of a lesser offense, but we'll go back at sentencing and say be nice to him. If the word got out, the jurors could attenuate their verdict by coming back at sentencing and softening the blow. That would be very counterproductive to the cause of justice.
So I recognize from the nature of the questioning that there may be some strong policy reasons that you can think of not to endorse this. But as trial counsel in a murder case, What we need to do is look within the allowable law and within the scope of, what's allowable. And
Sounds like you've said what you need to say on
And you're
that
going to
one.
stand on, as I say, you'll stand on your brief on that point.
I'll stand on my brief.
Can I turn to the issue of the testimony of Pearson? Based on your brief, are you arguing that essentially jailhouse informant or conversations should be excluded as a matter of law? It seems like you were coming pretty close to that.
I mean,
I know you want to, but are you?
I think that the court has to look at the nature of what the proffered testimony is and the circumstances of it. And without any kind of corroborating extra details that may have only been able to come from a non-public kind of source, I think courts should be very cautious about allowing these jailhouse informants. I mean, the state goes around and surveys former cellmates and other people in jail and invites these people to come forward in every case. In this case, offers inducements, makes representations and promises. The state was quite candid in this case that they were willing to offer consideration for this inmate to come forward. And all he was prepared to say is that my client had, quote unquote, confessed to him of murdering this other guy without any details. I mean, I really don't think
I thought there were some details. I thought there were quite a few
They didn't come
details.
in, but
Right.
Well,
But
I don't think
had he continued to testify, and that leads to my other question, which I'll get to in a moment, but had he continued to testify, there were going to be more details than just that statement. But my real question is this. Your motion in limine sought to preclude Mr. Pearson's testimony.
correct.
His testimony was essentially precluded, right? He said he made one or two statements, that was it. Why isn't this issue really kind of synonymous with or overlapping with your fourth issue, that is the mistrial issue?
I'm not sure I fully understand.
Well, what else would you expect from a motion in limine? He testified very briefly, and then the trial judge excluded all of the rest of his testimony and dismissed him from the stand.
Right. I mean, after he made the comment that my client had been in jail and was in jail for murder.
Which goes to your motion for mistrial.
Oh, I agree. I mean, I agree with what you're saying. Yeah.
And on that misstep, the judge did every possible thing short of a mistrial to remedy the difficulty.
I agree.
And a mistrial is only granted in the most extreme of circumstances.
Right.
Okay.
I mean, in the big picture, you kept out a lot of stuff in this case in terms of some of the pretrial maneuverings and everything else,
I mean,
which was why the statement of fact of the evidence was almost a little hard to follow. It turned out there was a lot that was missing.
right. I mean, in this case, I do believe the trial justice, granted a lot of our requests and was very favorable, but we have to focus on those issues that
understand.
didn't go our way. So I'd be happy to answer any other questions, but if there aren't, I'm happy to
They
take
don't
my
appear to
seat.
be in.
Thank you.
Attorney Sibley?
Thank you, Chief Justice Stanville. Your Honors, may it please the Court. The trial court's evidentiary rulings in this case were not an abuse of discretion. The screenshots of the text messages between Claudia Pendleton and her father, Mr. Pendleton, satisfied the low burdens for admission of authentication, relevancy, and the best evidence rule. Claudia Pendleton's testimony, substance of which the jury heard from two other witnesses, and on which Mr. Pendleton cross-examined her, directly related to the state's theory that Mr. Pendleton is violent when he is intoxicated, and he was violent and intoxicated when he strangled Kevin Curett to death. The trial court also conducted a proper Rule 403 and 404 analysis regarding Mr. Pearson's testimony. Again, Mr. Pendleton's own words were going to be the most probative evidence related to his state of mind. And further, the trial court acted properly by striking the few statements he did make from the record and issuing a curative instruction that sufficiently addressed any potential prejudice that could have resulted from that one brief statement. There is no evidence in this record that the jury did not follow the trial court's instructions. And finally, the trial court did not abuse its discretion by declining to consider the juror's affidavit at sentencing. Inquiry into or consideration of the communication between jurors during their deliberations would undermine the secrecy afforded to those deliberations, which is necessary to protect the free basis of discussion our system depends on to ensure just verdicts. Happy to take questions.
The jury heard evidence here that Pendleton is an alcoholic. Is that true?
Yes, that he...
They heard evidence that when he becomes intoxicated, he can become violent and aggressive.
Correct.
Sounds like character evidence, doesn't it?
Well, it went to the, again, to the state's theory that...
that because of his character, he got drunk and he got violent and killed somebody.
Well, it's something that he happens when he is intoxicated, and frankly, in some ways, I believe it actually worked to his benefit. The court did give a jury instruction on intoxication and how that related to whether his conduct was intentional or knowing, and the jury found that his conduct was, in fact, not intentional or knowing. Now, we do not know whether if it was based on his intoxication. But
the state's evidence about him as a person painted him as a, well, fill in the blank, any negative pejorative term you can think of to describe a person in a negative way, really painted him as one of those. So he started with like 2 strikes against him because he was one of those.
Well, the state's theory wasn't because Mr. Pendleton struggles with alcoholism, he is therefore guilty of murder. It went to his conduct and his state of mind as to when this event occurred.
There was an argument, especially in the reply, about how the rules about Facebook messaging and texts, and that our case law is kind of old school. So what do you think should be our modern view on best evidence authentication when it comes, because you can now fabricate these. So how do you prove, and how should we go forward proving that these are authentic and they're the best evidence?
And to be clear, not only can you fabricate, but it is far easier to do so now than it would have been, say, 10 years ago or 15 years ago.
Sure, Your Honor. I don't want to speculate on another case or what may come down the road, but really, I think our case law addresses these issues and what's really at the heart of it. It's up to the jury to determine whether the witness is credible and whether whatever the item is, in this case the screenshots, is what it purports it to be. It is for the jury to decide, yes, we believed Ms. Pendleton that she received these from her father, or no, we don't believe her. As I pointed out in my brief, expert testimony can be helpful in some cases. There are certainly cases that could arise where it would be necessary. In this sense, I believe it was the Churchill case. There were 2 originals here, and Ms. Pendleton walked through everything that we would expect of a witness. He is my father. We communicate through text messages. This is the number that I have saved as him. She was able to identify his kitchen.
What about the appellant's argument saying that in this day and age, when fakes appear absolutely real, that you really do need to dive into the metadata? You need to go into his phone and check the digital data showing that in fact that was composed on his phone, and going to the carrier confirming that yes, in fact, on this date and this exact time, something was transmitted from this number that went here. Does the state this is crystal ball gazing, is the state in the future going to have to really dive much deeper, as opposed to just saying, well, here's the victim's phone and this is what's on it, and the victim says, well, this sounds like something that somebody was sending to me?
I really think that would have to be on a case-by-case basis, and again, here we have Ms. Pendleton testifying to, this is my phone, and they were the screenshots, they were as they were displayed on her phone. Now the ones that's
been the gold standard so far. It's the person who gets it says, yeah, it came from the number, it sounds like this person popped up on my phone, it's absolutely, I believe it was them. But I'm just thinking forward down the road, you're going to get some jurors who will say, yeah, I can fake that in 2 seconds and put it on your phone, make it look like it was coming from somewhere else.
And that is their purview as the fact finder. The jury in this case could could have, it would have been well within the right to completely reject her testimony and say, we don't believe he sent these, we don't believe these came from your phone, we don't believe you at all.
Will we see expert testimony more and more in the future? I understand there were some designated in this case, but it was late and therefore excluded.
Potentially, yes. It would really depend on the case and on that particular facts and the way that either the state or defense would want to use electronically stored data.
From the perspective of the best evidence rule, were these originals? Were these screenshots originals?
Yes, because when electronic data is sent, two originals are created. One that's retrievable from the sender's phone, one retrievable from the recipient. In this case, Claudia Pendleton. The screenshots were taken as the messages were displayed on her phone.
I went to an evidence seminar where the speaker said, the best evidence rule is an anachronism. It doesn't work anymore. It's embarrassing, when people even raise it, because we're in a whole new area of photocopies, faxes, facsimiles, and all the rest. And the standard going down the road needs to be one of flexibility. Would you agree with that assessment?
I think flexibility is always helpful. It's why we refer to reasonable articulable suspicion as flexible within some boundaries, probable cause as flexible within some boundaries. There's a reason, we don't have bright line rules for certain things, because we look at things on a case-by-case basis within the guidelines of the Constitution and this court's case law.
So it depends.
My favorite lawyer answer, it depends.
So let's talk a little bit about the sentencing issue and the input from the juror. Now, my understanding of the federal rule is that when a jury as a whole recommends leniency, it's generally considered surplusage and not considered binding. Okay, and that makes sense. But why isn't it something that would be relevant? What if, a juror says, we all thought you should be lenient with this guy. Why isn't that useful information? Nothing forbids it in the sentencing. So should it automatically always be stricken? Or should it be up to the individual sentencing judge? Or what should be the standard?
I think at all possible, we should stay away from delving into or inquiring too much of the jury's deliberations so that we do not affect the secrecy, which really gives each individual juror the ability to speak their mind.
What if it was a statement by, the whole jury, whether it's on a verdict form or otherwise, as opposed to an individual juror purporting to report what the jury talked about?
A verdict form could be very different, though we see those in a lot of cases, especially complex ones with multiple charges, and so you can see their thought process.
And if it says, go easy on this guy.
Not sure that would be included in a jury form.
No, write it on.
I think about it in this case, if I was a different juror who was sitting on the jury, and then somebody else's perceptions of what I thought or what I said was now out in the open court, if I were to ever serve on the jury again, I think I would have some real reservations.
And is that really the issue where the judge said the reliability, because one juror is purporting to speak for the thought process of the whole jury? So putting aside whether it should ever be admissible, that alone, in terms of reliability, is a reason to keep it out in that context, certainly within the discretion in any event of the sentencing judge.
Right. I think it's, as a overarching general rule, it is best not to be delving into the intricacies in the specific communications absent the already recognized exceptions of jury deliberations.
Well, every standard jury instruction in every trial, every criminal trial, the judge instructs the jury, don't worry about it's not your role to do sentencing. That's the court's role. I mean, that's a pretty basic fundamental divide, isn't it?
It is, and it's also why they're instructed that they, I'm going to inartfully say this, but they shouldn't necessarily be thinking about the consequences, which sentence can be one of them. They are to think about What is the evidence presented, to weigh it, to assess it, and figure out whether the evidence beyond a reasonable doubt proves whatever the charged crime is.
Would it have been an abuse of discretion if the judge had decided to rely upon it?
Well, given that the rules of evidence don't apply, maybe, like Attorney MacLean, I couldn't really find anything
It depends.
on point. Yes, it depends. I could speculate a situation where it potentially could be an abuse of discretion, but since that's not the issue here, by declining to consider it, the court did not abuse its discretion.
It could also be, from a defense point of view, be careful what you ask for, because jurors might have very definite opinions in some cases.
Very true. You could think about a different case where the individual is actually convicted of murder, say, and inquired to the jury deliberations, and the information that comes out, say, falls very heavily on the aggravating factor side of the second step analysis. And so best to stay away.
Our Rule 606 jurisprudence is very clear that we don't inquire into the thought processes of the jury. There's a recent case, State versus Coleman, I think. I happen to be the author of it, where we went into Rule 606. The issue was a witness had said something to the jury as he was leaving the witness stand, and we said it was appropriate to determine the effect of the external influence on the jury. But we said in that case, no way do we examine the jury's thought process as opposed to the effect of external influences. Comments by witnesses, if a juror saw a witness, etc. We've clearly differentiated between internal and external influences on the jury.
Yes, and sure, I absolutely think that makes sense. If I remember it, in the Coleman case, the witness, as he or she left, said something like, "Good luck." Well,
right.
In that case, I do believe it is appropriate for the court to inquire as to whether that external information affects the jury's or a juror's ability to remain fair and impartial, because certainly if it did, then we have a problem. But as Your Honor pointed out, that's not the thought process of thinking through the evidence, assessing the evidence, assessing witness credibility. Two very distinct, separate things. Thank you, Your Honor.
Thank you. Attorney MacLean, you get a couple minutes of rebuttal.
Sure. What about that proposition that we draw the line, we exclude any inquiry into the juror's deliberations or thought process, but we do and should look at whether external influences such as interaction between a witness and a juror, or a note, something said to the jury by a witness. Do you see the distinction between those two, and where does this case fall? Which category does this case present?
Well, I mean, I have no issue with the court's jurisprudence on Rule 606. I mean, all of the cases have dealt with the context addressed by Rule 606, and that is either use in trial or looking into the validity of a verdict or of an indictment. That's what all of the jurisprudence is. We've never had a situation where some clever defense attorney has tried to use a juror information for another purpose. I think the court will have to look at some of the policy issues, in the jurisprudence that you have developed, and look at whether this is prohibited. I mean, it is interesting in this case that, at least according to this juror, my client, that the victim died of hypothermia, that the jury, according to this juror, found that my client hadn't engaged in any physical acts, leading to this person's death, and that he was convicted under the theory that he had not summoned medical help.
But that was one person purporting to report what the jury did, which would require the judge to inquire of the jury's thought process, which would not be okay. That would cross the line.
It certainly wouldn't be prohibited by Rule 606, but it would contravene the policy that, I think the court is
Well, do we want a circumstance in which we have dueling jurors coming and presenting evidence to the sentencing judge as to what the judge should do?
No, I think there would be a lot of room for mischief.
Yeah.
So,
Thank you.
anyway, thank you very much.
Thank you, counsel. And as is our usual practice, we'll be taking the matter under advisement and issuing a written decision in due course.